Well, everybody, it's that time of year again, and we'd like to welcome everybody back to the Phoenix Center's, dare I say, 10th annual Telecoms Symposium. Funny, I was in my garage, and by the way, if anybody wants some, I've got a whole box left. This is the giveaway we gave 10 years ago, 2001. And as the old Stephen Sondheim song goes, we're still here. So we are really happy. I mean, we've come a long way in 10 years for what we've been doing, and I thank everybody. I'd like to also thank those of you in the audience who've been with us the whole 10 years. I see a couple old friends that have been, even went to our very first symposium, so we're very, very appreciative of that. So starting from our humble beginnings, what have we done lately this year? So this is my quick State of the Phoenix Center address. Once again, an incredibly another prolific year. We issued 10 papers this year, and on top of that we have 12 papers published or accepted for publication in academic journals. I would defy anybody else to match that record. A couple of major ones that we've done, the Broadband Adoption Index, which was published in the FCLJ. We did a paper on FCC merger reviews, which was published in Commonwealth Conspectus. Believe it or not, there is actually law on the FCC's merger review authority. They just never pay attention to it, but if you're interested, there is that. And a very interesting paper we got published in the Yale Journal of Law and Technology on the cost of substandard patents. So we're very, very proud of all that stuff. A couple op-eds, press hits, radio play. George and I both did NPR this year a couple times, speeches, etc. But of course, the big thing is not just your output, but the relevance to the debate. And I think that's borne out by a couple of different things. George continues to remain in the 1% of authors downloaded on the Social Science Research Network, which is quite an achievement. I'm in the top 2%. Just on Westlaw, which are legal journals, we were cited, I think, about 10 times in the academic literature this year alone. Surprising though, we had about 1,200 hits a day on our webpage. We've got a couple of major sites. The Broadband Adoption Index was cited by the GAO. We're very proud of that. Extensive positive citations from the FCC. National Broadband Plan, the competition analysis was basically our Sutton model that we developed. They also cited our poll attachment order. They cited our Valley of Death paper. Same thing with the 14th CMRS report. They cited us, in particular our Sutton model, which is, I think, the correct move of where we need to go in analyzing competitions. We're very happy about that. That said, as I'm sure many of you know, we did have some recent unpleasantries with the FCC over our jobs multiplier. But fortunately, we've all made nice. In fact, we have a lot of people from the FCC here, so we're very, it was really rather amazing how much of a reaction of one paper could cause, but we had a good time with it. And then I guess, it always amazes me, every time we do these symposiums, always the night before, there ends up being some giant, amazing announcement by the FCC. I don't know why, but coincidence seems to hold. And as we all know, yesterday the chairman announced a new open internet initiative. And the speakers are free to speak on whatever they like to. I just think it's sort of going to our relevance to some of the papers that we did. I would call everybody's attention to two papers they did. One was called Non-Discrimination or Just Nonsense, and the other one was a Broadband Credibility Gap. And you know, if you look at what the commission did originally, I guess when they first came in, the Open Internet, NPRM, and then the third way, these were absolutely flawed from top to bottom from both the economic and legal perspective. And most of the people, the record, if you look at it, you had either one side, there's 1,000 broadband flowers are blooming and don't regulate, and over here we had a terrible monopoly, we need to do this. And you know, given my particular background, a lot of people don't know this, prior to coming to the FCC in '94, I was an electric utility lawyer. So as I like to joke, I'm not proud of my rate-making background, but I have one. And there's actually 60 years plus of case law on undue discrimination, which the FCC seemed to ignore. By the way, as a quick footnote, if I hear one more person describe a telephone network just like an electricity network, my head's going to explode. They are not the same. Packets have to move from point A to point B, and they're not homogeneous, while electrons sit there and hum. And that's why you have magnets that ramp up and ramp down. And if you look at what the FCC did, they just took this non-discrimination standard and they just made it up out of whole cloth from Section 251. They said, we're not going to look at undue discrimination. They didn't want to look at case law. They had this, it was naked price regulation, and they violated the standard case law, which said, you know, we're going to force people to charge the same price for standard service and enhanced service. Now, that's price regulation no matter how you slice it. And it violates undue discrimination, which is you have to sell like products to similarly situated customers on the same terms and conditions. So it was just a real disaster, and we put in a lot of pressure on that. And so we called that out in these two papers. And not only we called out the non-discrimination problem, which I think was the heart of the FCC's the problem of the open internet stuff, but that fact Title II regulation would do that. We did an event study as part of the broadband credibility gap. It showed that, you know, stock prices did react. 10% drop in cable stock prices when the chairman announced the third wave. That's a fact. So, and not only that, you know, but trying to be positive, we had said, and if you look at the broadband credibility gap paper, which, by the way, is about to be published in Commonwealth Conspectus in about 3 weeks, there is a way, I think, that you can draft a Title I, a sustainable Title I theory if you tie it to some legitimate harm and hook it to the 251 interconnection provisions, and you can look at the analysis there. So whether the commission does it or not, who knows? But obviously, given that these papers were downloaded twice, both papers over 1,200 times, I think the FCC has gotten the hint. We can only hope. They are going the Title route. They're allowing prioritization and people for price to work. It focuses on due and unreasonable discrimination, case-by-case adjudication, and transparency, which, by the way, was already upheld in the courts for Title I authority. So we don't know, but thank the FCC for, again, providing us fertile grounds for a lot of research. So we have, again, that's my little speech. We have put together a phenomenal program for everybody today. We're going to start with a traditional economist panel, where we have sort of the best in the business. We will then have a keynote from Blair Levin, and then we'll have a panel on innovation and jobs, and then we'll wrap up with our traditional Jerry V. Duvall Public Service Award. So with that, time to get started. Thank you all so much for coming, and Jerry, why don't you take it away?
Thank you, Larry. Good morning. The Economist Roundtable is a recurring feature of the annual Phoenix Center Telecoms Symposium. For this year, we're very pleased once again to have a very senior level, experienced panel of experts that are going to discuss economic topics of their choice that relate in some way to the theme of this year's symposium, which is promoting investment, jobs, innovation. It may be somewhat oblique, but nevertheless we have allowed the panelists to choose their own perspective. Appearing on the panel this year, first, Tim Brennan, who is professor of economics at the University of Maryland at the Baltimore County campus. Jonathan Baker, who is currently chief economist at the Federal Communications Commission and on leave from the Washington College of Law at American University. We have Joe Farrell, who's presently chief economist at the Federal Trade Commission, on leave from the Department of Economics at the University of California at Berkeley. And I just might note parenthetically, a former chief economist at the FCC as well. And finally, George Ford, who is chief economist at the Phoenix Center. Our plan is to have each speaker talk for about 12 minutes. At the conclusion of the presentations, the audience then will be invited to ask questions of any of the panelists or to make a comment about what's been discussed. Joe has a prior commitment that he has to honor, be back at the FTC by 10 o'clock, so we will deviate slightly from that plan. We'll ask Joe to go first, and then we'll take some questions, and then we'll move on to the other panelists. Finally, on a procedural note, I note that the views of the panelists are only the views of the respective speakers, and they do not necessarily represent the views of their affiliated institutions or government agencies or the Phoenix Center. With that, Joe?
Thank you, Jerry. Well, when Jerry asked me to do, or when I talked to Jerry about what I would talk about, he said talk about anything you want. He didn't say it had to be related to promoting innovation, investment, and jobs, but I think, in fact, it will be. I'd also want to start by echoing, repeating what Jerry already said, that what I'm talking about are my views and shouldn't be taken to represent those of any commission or commissioners. What I'm going to talk about this morning is one, not the only, 50,000-foot view of antitrust and competition policy in natural monopoly industries. So traditionally, and if you read some textbooks, you will find still the view is that antitrust is about promoting horizontal competition among existing firms. And that is part of antitrust's mission, or part of competition policy's mission, but there are also important industries where that's infeasible, unrealistic, or would require such radical intervention that it seems unattractive. In some industries, for a variety of reasons, you can't expect a lot of direct horizontal competition at any point in time. So the question is antitrust then vacuous, or does it have a different related mission? And I think the answer is the latter. And I think one can understand this by thinking about two aspects of the scope of a monopoly, be it, however, natural. So let me pause for a moment about natural monopoly. People use that phrase in a variety of ways, some of them precise, but I think more than one of them precise, and so the coexistence of different precise meanings destroys the precision of each. It's sometimes used to mean an industry where you can't expect competition to thrive and survive. So it's a prediction. Other times it's used to mean an industry where you don't think competition would be a good idea. In classic natural monopoly terms, where you're talking about economies of scale, those two ideas are related, although not identical. In other areas, they may differ more, or perhaps less, but it's worth being aware that both of those are out there. Other forms of natural monopoly are those created by proprietary network effects, and those created by drastic innovations, perhaps potentially leapfrogging drastic innovations. So what does antitrust say about those? I think it's worth focusing on two aspects of scope, as I say. One is temporal scope. How long does a particular reign of a natural monopolist last? And the other is vertical scope. How far do these natural monopoly tendencies extend? So temporal scope is perhaps the more traditional, well, they're both traditional. Temporal scope is how does it happen, and what does antitrust say about how it happens, that these natural monopolists eventually get supplanted by their successors. Okay? It seems to me that what we know about entry strongly suggests that it's very important whether or not it's possible to enter gradually. And so one of the things I find that we often worry about in natural monopoly industries is whether the natural monopoly seeks and finds ways to forestall gradual entry. There may be nothing it can do about overwhelming, dramatic entry by, let's say, a dramatically superior technology, but there may be a lot it can do about other forms of entry, including gradual, initially small-scale entry. And so one thing to be concerned about is how does a natural monopoly handle that possibility? So if we think about network effects, for example, one can analyze, and it's an interesting question, important question, and one that I've spent a bunch of time analyzing, whether conditional on incompatibility, so that small-scale entry with strong network effects is not viable, whether the incentives for displacement of one network by an incompatible network are basically correct or wrong in some direction or another. But in analyzing those things, we shouldn't lose sight of the fact that entry is apt to be a lot easier and competition, at least in direct terms, stronger, if it's also possible to enter with a compatible but different or separately supplied product. Okay? I sometimes think that the emphasis that we hear from some on, well, it may be difficult to enter, but boy, it's awfully rewarding because then you get that lucrative and long-lived natural monopoly, is a little like saying, well, you may have a brutal dictatorial regime with secret police and informers and so on, but boy, people will try really hard to turn the secret police and overcome the barriers, because then they get to be the dictator. That's, I think, neither realistic nor salubrious. And although I don't suggest that the analogy carries over in all respects, it's worth recognizing that just because there are very strong incentives to become the natural monopolist doesn't necessarily mean that temporal scope and entry to replace an existing natural monopolist is all fine. So what do natural or other monopolists do to prevent gradual entry? There's a whole range of things, of course, and that leads you into a well-trodden and classical area of antitrust. I want to talk for a couple of minutes about one that we at the Federal Trade Commission have seen a couple of times recently. As you all know, the Commission in the last year or so settled an investigation against Transitions, which is a firm that makes lenses for eyeglasses that go dark in sunlight. And one of the things that Transitions promised not to do, and it's important to note that this was a settlement, so there was no admission of liability or that they'd done the things that they promised not to do. Transitions agreed not to offer market share discounts. You might also have heard of another investigation against Intel, where a settlement contained similar provisions. So what is it about market share discounts that might worry somebody in competition policy? Well, first of all, I think it's important to recognize that calling them discounts is a loaded way of describing them. Okay, so we're talking about a system under which a firm charges different prices depending on the market share that it achieves with a particular direct buyer. And there are no more discounts than there are surcharges. You can phrase that one either way, and it's equally descriptive. But more importantly, to think about the economics, what's the impact of pricing that depends on the share of sales? So first of all, as with exclusive dealing, there are a variety of circumstances in which the impact is unlikely to be anti-competitive. If, for example, some direct buyers can specialize in buying from a rival, then there may be no effect or no harmful effect from this kind of arrangement. But if each direct buyer feels it necessary to buy the bulk of its purchases from the monopolist, what's the effect of this market share discount/surcharge scheme? Well, if you think about a firm that offers a pricing policy that says, here's how much you're going to pay me, it's the list price, P, times 1 minus a discount factor, D of S, where S is the share of your sales that come from me, okay, times the quantity of sales that I make to you. Okay? So that says the unit price, the average price, is P times 1 minus D of S. What's the consequence of this? Well, of course, that means that the marginal price being charged by this seller is not only less than P, but less than P times 1 minus D. Because by buying more, you're increasing its share, and so you're getting, and in fact, it turns out, you can work it out. Sorry, there's no blackboard here. It's P times quantity 1 minus D minus S times D prime. Okay? So that's the discount part. What's the marginal price to the direct buyer of buying from a rival who's charging a price R? Well, it's not only R, but it's, in addition, the impact on what you have to pay to the monopolist. Okay? I'm not going to give you all the formulae because I can see some of you trying to work it through in your heads and others just rolling your eyes. But when you work it through, and this, among other places, is in a paper that we're going to be publishing soon in the Review of Industrial Organization. If you work it through, you can find that the monopolist can, against a rival who's charging marginal cost, can charge a price that's a multiple of marginal cost equal to 1 plus a fraction given by S squared times D prime divided by 1 minus D minus S times D prime. So again, I don't expect you to digest that formula if you don't happen to already know it on the fly. But the point is, if D is constant, that says you don't have share-dependent pricing, then, not surprisingly, the monopolist can't keep its control of the market without charging cost. But if S is bigger, and if D prime is significant, then the monopolist can charge an effective marginal price, even taking account of the full marginal unit discount, that's well above cost, and still make it impossible or unattractive for the buyer to buy even from a rival who is charging cost. Effectively, this surcharge or discount scheme taxes transactions between the rival and the direct buyer. Okay? In my view, that's a significant competitive problem when S is large and when it's not plausible, not a viable approach for the rival to trade through other direct buyers. Okay? Now you might say, well, so don't you have to calculate whether given P and given the function D, it's possible for the rival to make sales if it charges marginal cost. That's essentially a cost-based test, although a more sophisticated one than we often see that would look only at whether P times 1 minus D or P times 1 minus D minus S D prime is less than cost. But even then, I don't think many people in this city would have the chutzpah to argue that it's okay to tax an industry provided the tax doesn't exceed the pre-tax gross margin. Simply on the grounds that if the firms were willing to price down to marginal cost, they could then sell as much as they were planning to sell before. Okay? That argument, I think, would not be greeted with a lot of enthusiasm, and I think there are reasons for that, both short-run and long-run reasons. And so it seems to me consistent with the settlements in the cases that I mentioned that this is a real issue. Now, I'm going to steal a couple more minutes, if I can get away with it, and just talk for a moment not about temporal scope and about these entry issues, but about vertical scope. So vertical scope, of course, since Carterphone and Hashaphone and MCI, has been a major issue in telecommunications, and it's an important issue in natural monopoly competition policy more broadly. As some of you know, Phil Weiser, who you'll be hearing from later, and I wrote a paper on this issue, stressing the idea that with a range of exceptions, and I do still sometimes wake up in the middle of the night wondering whether exceptions was the right word to use, or how much of the analysis they swallow. But with exceptions, a monopolist has efficient incentives to choose its vertical structure. Okay? What I want to do today is to leave you with what I hope you'll find a nagging question. I do. If we look at the finance literature on mergers, it turns out that for the acquiring firm, mergers are often unprofitable. So the internalization of complementary efficiencies view of the world that says if you can trust the monopolist to do what's profitable, you are then trusting it to do what's efficient. You might wonder how that analysis fares if we think, as I think the finance literature does suggest, that empire building coexists with profit seeking in firms' choice of mergers. So I'm over time. Let me leave it at that, and I'm happy to take a few questions.
Thank you, Joe. Any questions of Joe on his presentation, his thoughts? And yes, it is consistent with the theme, Joe.
John, Georgetown. Joe, thanks. Really clear remarks. Going back to your taxonomy of the different possible uses or types of natural monopolies, my policy and your perspective toward entry in the very first instance really, though, depend upon which of those natural monopoly types is emerging. If you looked at, for instance, a true, honest-to-goodness economies of scale, economies of scope, natural monopoly, a sub-additive cost structure. In that particular instance, does it matter that in that instance, entry may actually raise social costs relative to your situation that you described, which was the network type of natural monopoly? Does it make a difference what type of natural monopoly you're doing?
Thanks, John. It easily might. I'm not entirely convinced by your example, and let me say why. First of all, I think facing entry, is this not working? First of all, I think facing entry is both a good discipline for an old-fashioned cost-based natural monopoly and a useful test for those who claim that such and such an industry is such a natural monopoly. So I think there's an issue there. I also think it's true, and this is an intriguing line of thought that may take you to where you're going about it depends what kind of natural monopoly, but I'm not sure. If you're talking about digging up the streets to lay a bunch of new wires, there's a major social cost to that, and in some sense it's a good thing. Not so much if that doesn't happen, although you could argue that, but at least if an entrepreneur who thinks it would be a good idea has to persuade other people first before he goes ahead and does it. In other areas, such as innovation-based natural monopoly, I think most of us would feel that it's a better world if somebody with a bright idea that he wants to pursue doesn't have to persuade a bunch of other people first, but can just go ahead and do it. So the kinds of costs that are involved in entry may, as you suggest, affect the right policy and affect the way we view these things, but I haven't explored that thoroughly enough to really know.
One other question?
Yes, I wanted to get you to give us the title of the paper so if anybody wants to look it up, they can do that.
Oh, the paper with Phil Weiser?
No, the one of the procedure.
Oh, the RAO paper. The title, it's called something like Economics of the FTC 2010. So the Review of Industrial Organization has annually several articles by the economic teams at government agencies, including the European Commission and including the FTC.
One more question? Joe? Okay, Joe.
Okay.
Thank you very much.
A few minutes if I may. But
okay. Tim?
Yeah, especially since it's Tim, because he was accusing me of bolting whenever he starts to speak.
I was just at a conference where Joe did that, so I was giving him a hard time. Thanks. This is the. Okay. When George asked me to do this, and I'm really happy to be here, I said, well, you know, I haven't really done that much new in telecom lately. I've got a paper out kind of on another way of looking at net neutrality issues, but I actually talked about that at the Phoenix Center 3 years ago. What do you want me to do? And he said, why don't you take a look at the FCC's Phoenix order? And my reaction to that was, you mean you guys are writing the FCC's orders now? It's like you're in heaven. I mean, it's like why not just close it up? You've already won, right? So not being exactly sure what to do, I decided just to kind of throw out what I might consider 10 nagging questions, perhaps in the form of the ubiquitous top 10 list. So let me sort of run through these, and I'll say something later at the end. Now, you may think that I put Blame Canada up here as a pathetic attempt at hipness by making a South Park reference, and to some extent you'd be right, but I spent 2006 at the Canadian Competition Bureau, and one of the big issues that it was confronting at the time was what to say to the Canadian Radio, Television, and Telecommunications Commission, CRTC, yes, its FCC equivalent, about what to do about whether to deregulate or the criteria for deregulating local telephone service. In Canada, the federal government regulates local telephone rates. And so there was an extensive debate there about is 2 enough, how big should shares be, and so on. So a lot of the issues that have come up here, and I'll refer back to some of these later on, have also come up there, and they may be instructive both substantively and to some extent procedurally. What happened was that the Competition Bureau actually recommended a more sort of liberal position, if you will, than even Bell Canada took, in terms of basing, hey, if there's a second strong competitor out there and there's no evidence of collusion and so on, just go ahead and deregulate. The CRTC disagreed with that, but in Canada, essentially the cabinet can overrule the regulator, which it did in that case, so that may or may not be instructive. The antitrust ball is in the FCC's court. I agree a lot with much of what Joe was talking about. But I just sort of wonder whether antitrust is available procedurally as a remedy in the wake of Trinco and the Credit Suisse decisions, which basically, as I read them, have essentially said that if there's a regulator in place with the authority to handle competition issues, then the Supreme Court has basically chased the antitrust agencies out of the picture. I believe that one of Joe's colleagues, Howard Shalansky, is making an argument that that might only apply to private antitrust cases, not public antitrust cases. I hope Howard's right if that's his argument, but I don't know whether he would be purely as a legal matter. Next, you see a lot of references in CRTC things, FCC things, other agency things about, say, well, we're worried about whether a firm has market power. What are we going to look at to see whether someone's got market power? Well, let's look at these merger guidelines that everybody's got. And it's worth keeping in mind that the merger guidelines are designed to answer a different question whether an individual firm has market power. They're designed to answer a question whether a combination of the two firms will make matters worse. Whether you do it through a traditional market definition approach or through the upward pricing pressure approach that Joe's helped pioneer, is a different kind of question. But I don't think, I sort of have strong doubts about whether merger guidelines is a good way to look at the question about whether somebody has market power and therefore should we do something about it. There are references to network sharing a lot of times. It's even come up here a little bit. And there is certainly, I should have said, isn't only about market power. Certainly, Joe is right that for instance, refusal to allow interconnection can be a way that an incumbent monopolist can help solidify its position against gradual entry. But you may have a problem. There may be a public policy reason to worry about interconnection, even if your markets would appear to be perfectly competitive or very close to it. There's lots and lots of participants. If the setting of the terms of interconnection involve all of these competitors getting in the same room and deciding what they're going to charge each other, say, to transmit each other's traffic, you don't have to have a huge imagination to wonder what happens if you invite all the competitors in the same room to set prices for services that they commonly charge to each other. Perhaps relatively unique, just to sort of plug something I mentioned before, there's this net neutrality discussion that's out there. Larry just referred to it again. And that argument is almost always seems to be framed in terms of whether you're some incumbent ISP that's got some sort of market power and is going to use that in some nefarious way. Perhaps those stories are there, but I've actually been thinking more about it in terms of a network externality of sorts, which is if I put up a website and put a link on it, it would be nice to know that others could have access to that link if they click on it. That doesn't mean you treat everybody the same, but it might put an argument out for, suggest an argument for some sort of minimum quality standard, and I'll sort of throw that out there. A common thing you see in a lot of regulations is it's really important that they be non-discriminatory. I found this rather puzzling because a non-discriminatory monopoly price to me doesn't do a whole lot of good. Now, why is there so much emphasis on non-discrimination and not the price level? My guess, and you know, Joe and John could talk about this with more authority if they so choose, because they've been more involved in how these institutions work. But my guess is that when industries are lobbying agencies for regulations, they don't really care about the absolute price level that much, because to a first approximation, that gets passed on. What they worry about a lot is making sure that a competitor doesn't get a better deal on an input. So they want to make sure, in some sense, what's most important to them is not whether the price is here, but whether the price I pay, I can guarantee it's going to be the same price my competitors pay. And so I think that's why non-discrimination percolates to the top in these proceedings, but it doesn't necessarily mean that the consumers who don't really have as strong a voice in the process get protected. Here at Raising Rivals Costs, I've been around the block on this many times over the years. It's predictably bad, I think, first, or is primarily only if the monopoly that we're talking about is regulated, and therefore they may get involved in various kinds of vertical discrimination schemes of one sort or another to try to extract profits that the regulation wouldn't allow them to extract. I believe that may be one of Joe's exceptions in the ICE paper, but I can't recall for sure. There are other exceptions, or if one carrier monopolizes a related market. I interpret Joe's remarks about transitions in Intel as being somewhat along these lines with market share discounts. I've got a paper out on that subject as well. But I was prompted by looking at something in the Phoenix Orders, reminded me of an issue that's been around a lot about whether or not all telecom carriers should have access to all buildings. And that's always struck me as an argument that's somewhat similar to saying that every mustard manufacturer should have the right to insist that every hotel carries their kind of mustard and puts it on the table in the hotel restaurant. You know, if you don't like the carrier that your office building chooses, find another office building. I mean, the issue only becomes a problem if, in some sense, you've in effect suppressed competition among office buildings because you control all of them. And so there may be an issue about incumbency with these, but I think that this idea of building access, to me, has always been kind of exaggerated. The last two things I want to talk about are sort of procedural and raise questions of the most nagging of all. The first of these, I let Joe deny this, but he actually has gotten me thinking about this at a conference a few years ago, which is who should bear the burden in these regulatory proceedings? There are some notices that I've looked at over the last few years where you kind of get the impression that the regulatory agency, the FCC in this particular case, is basically saying to an industry, prove you're competitive, if not, we're going to regulate you. That may not be what's specifically intended, but it sure reads that way, as opposed to saying, you know, we're not going to regulate unless somebody proves that there's a significant market failure that requires it. Those two things can have much different outcomes because meeting burdens is not a costless procedure. Now, my gut feeling from being around this probably too long is that the burden probably ought to sit on someone who wants to make the case for government intervention as opposed to proving competition. But I don't know in my mind whether that's right or not. And so I think there is an interesting question there about how that ought to be framed and on whom the burden should lie. The last nagging question here, going back to Canada, is, should we regulate duopolies? There's a lot of people talk about, hey, these industries don't work very well because, say, with broadband, there's only two major, wireline providers, and wireless isn't much for competitors. So I'm not going to have any empirical evidence on that one way or the other. That's just sort of obviously a debate that's out there. But I'm not sure what the remedy is. Again, we've traditionally in the United States said that we're going to bring in the full force of regulatory price setting and everything that sort of goes with it, only if you've got, a natural monopoly that satisfies both of Joe's definitions and probably a whole lot more, in addition. So there's only one out there, nothing's going to change, and that sort of thing. And maybe some other things too, like that it's going to be a relatively static business, relatively crucial, and all sorts of things like that. We don't traditionally regulate duopolies on matters of price and access and things like that. Perhaps we should. Again, is this a gut reaction on my part, being averse to this, or is it more substantive than that? And that I don't entirely know. Let me sort of close with one thing, coming back to the theme of the conference, which I confess I'd sort of forgotten about, which is on this jobs point. If there's a reason, I wrote a dissertation on macro a bazillion years ago. And I'm perfectly willing to believe that things like stimulus packages and market interventions are necessary to overcome underemployment equilibria. I don't have a problem with that. What I do have a problem with it is invoking it as an argument for something else. Like, gee, information systems in healthcare would be a great idea. Let's put it as part of the stimulus package. If you want to do that, look around for things, and the evidence may not be very good. Is, what's the best way to make up for a shortfall in demand? Is it, by funding roads? Is it by keeping teachers in jobs? I don't know. Is it by supporting state universities? I suppose I should be big in favor of that one. But whatever it might be, that's the problem, and trying to use that as an excuse for something else is a bad argument. Not least of which because if we ever get out of this recession, then that basis for that policy, which might have been a good policy, would disappear. And if there is no recession, I'll just pass along a story which I found to be an epiphany, but will probably reveal to the non-economists in the room why you probably shouldn't trust economists with anything. Many years ago, when I was a staff economist in the antitrust division, somebody came and said that Richard Posner, who was, before he became a judge, was still a professor at Chicago. I think he actually still is a professor at Chicago, but when he was only a professor at Chicago, was testifying on a rail merger. And so, we all, kind of pathetic econ groupies that we are, we all sort of hustle over to the ICC to go check out Posner's testimony. We get there, and Posner's being examined by an attorney. Posner's testifying in favor of the merger, and an attorney opposed to the merger, I can't remember who was representing, was against it. And he said, Professor Posner, don't you know if this merger goes through that it's going to reduce employment by these merging companies? There'll be 2,000 fewer workers or whatever the number was. Posner's response was, that's not a cost of the merger, that's a benefit. If you think about it as an economist, he's absolutely right. If you can accomplish the same thing using fewer resources, and it liberates those resources to do other things, that's an economic benefit. And that perhaps shows you why maybe you shouldn't listen to economists. I don't know. Anyhow, thanks very much.
Thanks, Tim. Next speaker, Jonathan Baker.
Thank you, Jerry. I'm delighted to be here again for a second year to the annual panel of gray-bearded economists, and delighted to be on the panel with two old friends, as well as with one of my current colleagues, Jerry Duvall. One thing I've learned in more than a year at the Federal Communications Commission, and I ought to do the disclaimer that I'm speaking only for myself and not the FCC. One thing I've learned is that the competition issues that we have to deal with at the FCC are fabulous. They're as good as any that I had to think about at my jobs at the antitrust agencies or the White House jobs, but both of which I've shared in various ways with Joe and Tim. Just to suggest some of the things that we're working on at the FCC that are just interesting without talking about them. Comcast NBC merger, our open internet rulemaking, we're reviewing a regulatory regime involving special access lines, we're doing a quadrennial review of our media ownership rules, and there are all sorts of other things, and they're all terrific competition questions. But of course, almost everything I am working on is ongoing and subject to various confidentiality restrictions. So you will have to invite me again next year if you want to hear about them substantively. But I can talk a little about process. And so what I wanted to say first is that many of the issues that I'm working on involve a question of optimal regulatory strategy when there's uncertainty about future competition. So it's a sort of interesting academic question about how one would think about that. And I want to put aside issues that are obvious issues in the application of the error cost framework. We might dispute which outcomes are more probable and which ones are and what the social costs are. And focus on just this little narrow question of regulation when the costs and benefits of regulatory delay, are unclear. And make a simple point, that delay presents a trade-off for us as regulators, just as an agency. We have an option value in delay. So that if we take our time to make a decision, we avoid locking in what might end up being a suboptimal regulatory strategy, and we might avoid inducing firms to make sunk investments conditional on that strategy. But but that doesn't mean we should delay everything. Delay has costs. It creates regulatory uncertainty, which we hear a lot about in the public debate these days. And waiting may make the harms irreversible. So sometimes delay may be the right option, but sometimes action is the right option, notwithstanding the regulatory uncertainty. I've also spent time thinking about how the Federal Communications Commission uses economics and economists, and I thought I'd talk a little about that. And since Joe is leaving, I'm now free to talk about compare how the Federal Communications Commission and the Federal Trade Commission use economists. Joe, you understand, Joe and I have swapped jobs. I once had his job, and he once had mine. So I want to frame the rest of what I have to say by making some comparisons between the two agencies. First, with respect to merger review, and then a little more broadly. Now, I don't know if everyone realizes it, but they're essentially the same number of economists at the two agencies. And I will doubt you'll be shocked to hear that the FCC staff economists think about the economic issues in mergers the same way as the Federal Trade Commission staff does. We all went to the same graduate schools, and we studied the same curriculum and read the same articles, and we think the same way. And even so, except for Joe, who sometimes thinks in a different universe, but that's a plus. Even so, the agencies might see the same merger differently, and for several reasons. The Federal Communications Review, the FCC review addresses a broader range of public interest goals, not just competition. The antitrust agencies essentially major in competitive analysis with a minor in the specific industries like communications, and we at the FCC major in communications with a minor in competition when we're doing merger review. Settlement negotiations at the two places are conducted in the shadow of a different burden of proof, which is something like what Tim was suggesting. The antitrust agencies have to prove their case in court, but the merging parties have to show us, at the Federal Communications Commission, that their transactions in the public interest. The agencies obtain similar documents from the merging firms, but they test evidence differently. The antitrust agencies tend to rely on interviewing customers and deposing merging firm executives, while the FCC tends to rely more on voluntary submissions by third parties and its own expertise. And the antitrust agencies tend to prefer structural relief to avoid ongoing supervision of merging firms. And the FCC is routinely monitoring the industry anyway, so we're more comfortable with conduct relief. Now, some people have questioned having multiple agencies review communications mergers, on the ground that they claim it's unnecessary and wasteful. And people who take that view typically prefer antitrust agency review to FCC review. So I want to highlight just for a second 2 advantages of concurrent FCC review in advancing competition goals, just putting aside all the public interest work we do. The first is that we have our industry expertise and our broad public interest mandate let us take a longer view than's possible for the antitrust agencies. We can think about how the industry is evolving in a way that the Federal Trade Commission, say, or the Justice Department can't. And second, and relatedly, we can address potential competition issues more easily than can the competition enforcers, because it's particularly hard to prove a potential competition case in court. Now, beyond mergers, I've come to appreciate that there's a subtle difference between, in mindset, I guess you'd say, between the Federal Communications Commission and the Federal Trade Commission. Now, both are independent agencies run by 5 commissioners, and they both undertake rulemaking as well as adjudication. But the emphasis differs. The FTC thinks of itself, in my impression, as largely doing, the Federal Trade Commission thinks of itself as largely doing adjudication, especially on the antitrust side, a little less so on consumer protection. And the Federal Communications Commission thinks of itself more as a rulemaking agency. Rulemaking is quasi-legislative, and it tends to lead the FCC to take a broader industry-wide perspective on issues, and adjudication is more case-by-case. The distinction is not perfect because you have to understand how the industry works if you're thinking about how firm conduct matters for industry competition. But rulemaking, as a mindset, pushes FCC deliberations to look at matters a little more the way legislators do, in balancing views of and understanding views of competing interest groups, rather than than one might do at the Federal Trade Commission. And the difference is reinforced by the greater prevalence of district court litigation at the Federal Trade Commission. Administrative decisions at both commissions get appealed to the appellate courts, but the Federal Trade Commission is more often going to district court because it's more often adjudicating individual cases and seeking preliminary relief. Now, I'm not trying to say, when I say there's more of a rulemaking mindset, that this is not a polite way of saying that I think my current agency is captured by industry. In principle, agency capture could be more of a concern with a single industry regulator than with a generalist competition agency like the Federal Trade Commission. But the idea that the current Federal Communications Commission simply does what industry wants isn't borne out by what I've seen in my position. One reason I think is the nature of the communications industry. There's not a monolithic industry. There are interests of various sectors, the telephone companies, the cable companies, the satellite companies, and others are not always aligned with each other. And a second reason is we have institutional counterweights to represent the rest of society, a consumer bureau, a chief economist. My job is in some sense, in part, to play the institutional role at the Federal Communications Commission that the Council of Economic Advisors plays in the White House. But a third reason that I don't worry about capture is Chairman Janikowski's commitment to fact-based and data-driven decision-making, and his interest in promoting the more effective use of economics in industry decision-making. So let me sketch that problem. Too often I have the impression that in the past, outside economists have submitted expert reports to the FCC that look like economic analysis on first glance. They have the algebra. But inspection, you think hard about them, they don't seriously grapple with the questions that they appear to address. And economic submissions like that are less common at the Federal Trade Commission, when I would see them there. One reason for the difference, I think, is the more adversarial nature of the antitrust enforcement process. It's usually adjudication, not rulemaking. Most antitrust cases at the FTC settle, but both sides are the parties in those cases, the agency and the firms, are conscious of the possibility that there's litigation at the end of the road, during which economists would be subject to cross-examination on their submissions. So we've responded to the FCC by introducing an adversarial element into some proceedings during the past year. In two matters, we've invited economists who submitted reports to, in effect, confront each other's arguments in a moderated, on-the-record workshop that we held at the agency. And to help clarify opinions and get an adversarial back and forth going. Well, I guess I can't keep talking. I'll take the notes. Thank you, Bill. Because I want to remember what I wanted to say. Here we go. We've also addressed the problems testing economic evidence by hiring more econometricians. That's increased our internal capability to test empirical evidence that's been submitted for a review and develop and conduct studies of our own. And it also complements the efforts that Paul Dessau, who you'll be hearing from later today, who's the head of our policy office, has been making to reform our data collection process and make sure we have the information we need to do our job well. And we've supported the independent thinking of our agency economists by relaunching our agency working paper series, which will again be the home of independent research by agency staff, and you can find it on the website. So my hope is that when my term at the as the FCC's chief economist ends next year, that my successor will welcome the opportunity to join an agency that is widely respected for its careful and thoughtful economic analysis that it brings to bear on all its decisions. Thank you.